What is up, people? How is it going? I am here with the great OPTLawyer. How are you
Hi,
doing, good
everybody.
sir?
I'm great in this fine Sunday still morning.
Ah, yes, I woke you up, but I want you to know I don't apologize for a fucking thing.
You actually didn't wake me up, which is kind of a sad thing.
Ah, in which case I'm sorry.
Don't be.
Anyway, I want to go ahead and start off by saying this stream is not legal advice.
Uh,
Get yourself a lawyer who is worth a damn if you need legal assistance.
or if you know you're getting sued by somebody that has a case against you.
Yeah, that kind of thing.
Yeah.
It's eh,
Mm-hmm.
eh, eh. Okay, anyway, so we're going to be reading a document from the courts. And this is in the case of Steve McRae versus Kyle Curtis. And of course, it's going over the non sequitur bullshit that's been going on over the past how long now? Fucking a bajillion years now.
Well, at least one, but yeah.
Man. So we're gonna go ahead and get started into this. So guys, sit back, relax, enjoy, and yeah, pretty much that's it. I got nothing else. All right, let's start. Okay, you ready?
Well, yeah, let's go.
Are you sure?
No. Well, let's do it anyway.
It's okay. We'll wait on you.
No, I'm good.
We're still waiting. OPT, are you good to go?
Nah.
This is why I always ask the question,
Mm-hmm.
because I don't want to be rude.
Right, yeah. I'm good, let's go.
All right, here we go. So, guys, this is the document. State of North Carolina, Guilford County, Stephen McRae, plaintiff, v. Kyle Russell Curtis, defendant. Order on amended motion to set aside. So, OPT, if I remember correctly, Kyle was served at his mother's address. Kyle was like, nuh-uh, I wasn't living with my mother at the time. And, I was living with this guy, Benjamin Potts, at the time. Therefore, service is improper. And,
right, that's what he said.
that is what he said. And then Steve McRae was like, I call bullshit on that. And then there was some back and forth. There was a bit of tussling. There was a bit of argumentation going on through the courts. And then Benjamin Potts came in and basically did a player 3 has entered the game and drop kicked the ever living shit out of Kyle Curtis, and it was amazing.
Yeah, that's the image of like the dude running down with the Money in the Bank briefcase in wrestling.
It's like Undertaker goes to the top rope. Oh my god, it's a sewer slam.
Right, something like that. Yeah.
Yeah. Oh well, yeah, that kind of thing. Whatever.
It's that when that happened. I remember when Steve told me before he made it public that had happened, and I remember thinking, "Oh my god, you're just kidding, right? You're pulling my leg. There's no way this just happened." And he's like, no, he did. Like, and he showed me. Oh my god, seriously? Seriously? You guys have his roommate saying he never lived here? Oh god, why?
Dude, this is better than any pay-per-view I've ever
This
watched. It's great. It's fucking great.
This has legitimately been one of the strangest cases I've ever seen. We'll get into that.
Yeah, we'll get into that, but basically what I want to say is after reading this document, I believe right now I can die happy. If I walked out of my house and got slammed by a Mack truck that was attached to a rocket sled and it made the biggest human splat imaginable, I would have died a happy man knowing I just read this fucking document. So here we go. Number 1. This matter is before the court on Kyle Russell Curtis's amended motion to set aside entry of default and partial default judgment. The motion, ECF number 30. Having considered the briefs, affidavits, depositions, and other evidence submitted in support of and in opposition to the motion. Arguments of counsel at a hearing held on September 16, 2020, and relevant authorities, the court denies the motion. So please tell me what that means, because that's a lot of legalese right there.
Well, one, it means that the judge doesn't like holding the plot twist to the end of the document. He just likes to put it right out there, which is nice. But the fact of the matter is, that whole thing that we've been doing for almost a year now, as far as Kyle filing that motion to set aside, it's finally done, and it's over, and the judge said no.
The judge said no. The judge said, I don't fucking think so.
Yeah.
Nice. Factual and procedural background. Number 3. Plaintiffs served the civil summons and complaint in this action on August 30th, 2019. It feels like yesterday.
Right? I gotta say straight up, like 2020 has, at least to me, has actually just kind of flown by, because all the entire summer has like just been a mash of like 3 days. I worked from home for like 2.5 months straight, so just staying in here, barely going anywhere. It's like, yeah, days went by.
Holy shit.
Yeah.
August 30th, 2019. Fucking Christ. By certified mail addressed to Kyle R. Curtis at 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313. That address is going to be important. Ah, boy. Defendant's mother, Suzanne Curtis, who resides at the Pleasant Garden address, signed a certified mail return receipt documenting delivery of those materials to her at that address. So we have a return receipt signed by Kyle's mother saying, yes, I received these documents.
Yep.
All right, perfect. And says this. 4. The case was designated as a mandatory complex business case on August 23, 2019, and assigned to the undersigned on August 26, 2019. That means it was assigned to Judge Gale.
Yeah, the judge, the undersigned judge.
So the judge was like, okay, so I got this. Flip through the pages a bit.
Here's more likely thing. It's assigned to the judge. Working for a court, I can tell you what normally happens. It's assigned to the judge. The judge might look at the parties just to make sure he has no conflict with the name of the parties, and he doesn't tend to just read the complaint immediately, because, quite frankly, most of the time lawsuits get filed, initial discovery happens, parties settle, the judge barely has to do anything.
So it's not the way I was imagining it, where the judge was just flipping through the pages and going,
not when it was filed. Yeah, not when it was filed, no.
Damn.
Later, that happened, when motions started getting filed.
Then, at that point, he was flipping through the pages and being like, are you fucking kidding me right now?
Yeah. I mean, even granting the default judgment, he may have gone through the complaint. Well, like we know he did, because at one point he denied it because it wasn't verified or whatever.
Yeah.
But
also,
Also,
I don't want to cut you off, but I do want to say this. I would like all of you guys to look at the next highlighted portion, number 5. As a result, all proceedings in this matter have been publicly available through the court's website. So that means if any of y'all bitches, and you know who you are, want to file a privacy complaint against me, I will be fighting that shit. Fuck you guys. Anyway, you were saying, OPT.
That's pretty much done.
Okay, perfect. Yeah. On October 3rd, 2019, this court made an entry of default upon plaintiff's proof of service and Curtis having not timely responded. Number 7. On November 19th, 2019, in addition to the posting of plaintiff's motion for a default judgment on the court's electronic docket, the court mailed a copy of it to Curtis at his last known address, which was the one in Pleasant Garden. While that letter was not certified, Curtis has not denied receiving it. Ooh.
So let me explain what those two paragraphs actually mean.
Mm-hmm.
First of all, the court entering an entry of default is not the default judgment. That is the court recognizing that Kyle was in fact in default. He had not responded to the complaint in the 28 days that you're given to respond, or hadn't filed for an extension of time, filed a motion, had not appeared. So the entry of default is not the judgment itself. It's just, okay, he's defaulted, file your motion for default judgment, which is what Steve's lawyer did. And the court, because this must be a thing in North Carolina, because we don't do this in Ohio, but the court must apparently mailed the motion directly to Kyle at that address after it was filed.
Yep, it says here on 7 that it was posted on the electronic docket, which is the public access webpage that everyone is now familiar with, and a letter was sent to Kyle Curtis at the Pleasant Garden address.
Yeah.
And it says, again, on the highlighted portion, while that letter was not certified, Curtis has not denied receiving it, and the court's letter has not been returned by the Postal Service as undeliverable.
So that's the main thing when you're using regular mail. If you use regular mail to serve anybody through the clerk's office or whatever, if the clerk's office gets the letter back saying, that yellow sticker on it's undeliverable for whatever reason, that's the only way that said letter wasn't delivered. If that doesn't come back, then the court assumes that it was delivered to that address and the person who lived there got it.
Yep, it's reasonable. It's reasonable.
Mm-hmm.
So number 8, Curtis has maintained, for whatever fucking reason, that he had not received the complaint prior to the motion for default judgment being filed. He has not, however, testified that he had not been advised of the lawsuit having been filed against him. To the contrary, he testified that he was made aware of the summons and complaint against him through a link shared with him online in August or September of 2019. Big fucking oof. And guess what? Guess what's referenced? Kyle's deposition, which you can watch on this channel. I'll link it down below later, but yeah, you can actually see Kyle's deposition, and now, oh my god, it's a train wreck.
Now, before any specific people decide to start making noise about this paragraph, I'm just going to say that all the judge is doing here is stating facts. So far, this is not part of his analysis.
Yes.
He's just stating the fact that Kyle clearly knew this was a thing. He knew it. They're not saying service was good just because he knew it. Just want to point out, judge is only speaking facts here. Because some idiots are going to be like,
the judge is a Steve shill.
Yeah, basically.
Yeah, so basically like, what was it? It was like, Steve has paid off the judge. Steve has some dirt on the judge.
Yeah, I heard that crap.
Steve contacted President Trump, and Trump, through executive action, is making the judge rule in the way that he is. I don't know. Post your most crazy conspiracy theories down below. We'll read them later. So anyway.
Yes.
On January 23rd, 2020, having received no filing by Curtis challenging either service, the entry of default, or plaintiff's motion for default judgment, the court entered a partial judgment by default. And it was ECF number 17.
Yeah.
Number 10, on February 6, 2020, Curtis filed his initial motion to set aside default judgment, ECF number 19. Curtis thereafter amended his motion, can't imagine why, and filed multiple affidavits and documents to support his contention that he was no longer residing with his mother at the Pleasant Garden address at the time of service, but was rather living in Charlotte, North Carolina with Benjamin Potts.
I've never actually, in this entire thing, I've never actually looked up how far apart those two cities are.
85 miles.
Okay, so not like a trip down the road. Got it.
No, it's definitely not around the block. It requires a highway. It requires
Yeah.
buses,
Yeah.
especially when you don't have a fucking car. But whatever.
Right.
Let's see. On July 28th, 2020, among other materials, Curtis filed his own affidavit and a document purporting to be an affidavit from Potts affirming that Curtis lived with him at the time the summons and complaint were served. A lease bearing purported signatures of both Curtis and Potts, by which Curtis was to pay Potts rent, and discover bank statements from August and November 2019, purportedly mailed to Curtis at Potts' home address.
Can I just say I love the word purportedly?
I love it. I love it. For
Yes.
$5, what is that, CA? For $5 Californian, in fear of having to meet Reds in person, the judge is going along with whatever Steve says.
I think we got a winner right there.
We got a winner. We got a winner. Dim sum for $5 Californian dollars. You just won this battle.
Yeah.
All right, moving
I
on.
was going to put an open challenge for someone to come up with the best conspiracy, but
That
that's
is
it. We're
the
done.
best conspiracy.
We're
That
done.
is
That's it,
that
yeah.
is the best conspiracy. And by the way, some people are saying, well, couldn't he have just Ubered between the two addresses? Do you know how expensive that would be?
It's still not a trip down the road.
That's you're asking an Uber driver to make a 160-mile round trip. They're gonna be like, I'm making a fucking killing today.
Yeah, I mean they'll do it. It's just going to be a lot.
It's just gonna be a lot. Might as well just put a down payment on a car, make monthly payments be cheaper. Anyway, but it shows what Kyle submitted. He submitted a affidavit with Potts' signature on it, allegedly. He submitted discover statements with Potts' address on it that were supposedly mailed to him or whatever. Again, allegedly. And he was like, see, I do have proof that I moved. Therefore, Steve is wrong.
Yeah.
So that's what Kyle did. On September 9th, 2020, plaintiff filed an affidavit by Potts testifying that Curtis had forged Potts' signature on both the affidavit and lease Curtis had filed in support of his motion, and testified that, in fact, Curtis did not live with Potts in Charlotte at the time of service and had not paid Potts rent.
So,
Big oof.
Yeah, so I told you this off stream. I'll say it now. When Steve first told me that this had happened, I was in complete disbelief, I think is the correct phrasing for it. I also remember thinking at the time, because something insane had happened to me at work that day. Not to me, but like in court. I'm like, holy crap. Like, I don't think you can tell me anything that's going to like blow my mind any more than that. And then he told me this, and I'm like, you did it. I don't know how, but you did it. You blew my mind more than this crazy thing that happened at work. You don't see, you do not see this in civil case or cases. It's not that you don't see it ever, but this is not something that happens.
So basically, guys, OPTLawyer was like, look, guys, I've seen some crazy shit. And I have to say, wow.
Yeah. No, it is absolutely the most insane thing to me that, forge a signature here and there, whatnot, I guess. I don't know. But, the fact that he creates an affidavit and it's completely false and a forged signature, at least some people are smart enough to try to have somebody sign a blank piece of paper before they pull that off, but no.
Yeah. For Mortine Nielsen, for $45 someone pitched a tent behind our garage. I am afraid to look who. It might be Kyle hiding out. Thinking emoji. Do you have any bear mace? Anyway, that's a problem for another stream. We must continue. Plaintiff also challenged the authenticity of the Discover bank statements Kyle submitted, in part by providing evidence that the address label had been falsified on the document Curtis submitted to the court, and the correct mailing address was Curtis's Pleasant Garden address, at which service of the complaint and summons had been made. Big oop again.
Yeah,
Oop
again. Judge is just going over all of the facts in the record right now. He's not making a decision yet, not analyzing any of this. These are just the evidence that he's presented. Yep. Has been presented, or the relevant evidence anyway.
So basically, the plaintiff, being Steve and Steve McRae's lawyer, was like, hey, listen, Kyle Curtis submitted this, and I'm going to have to tell you, Judge, he's fucked up here, big time here in the address field.
Yeah.
Also, have you checked out this barcode?
Yeah. I mean, we'll go over all of that later through this thing, but I'll say it now. I said before, I've never seen like a case this crazy earlier. I've never seen anything like this at all. Like this whole thing, it's so crazy.
Jeez, this could be
literally just to get out of like turning a YouTube channel over and screwing with Steve. That's it. Like that's why this is going the way it's going to go. But yeah,
can someone please make this a thing? Please, someone in the criminal justice system. Court cases involving YouTube channels are considered extremely lame, and no one cares about them. We send these to a special unit on YouTube, who also mingle on Twitter sometimes. These are their stories. Number 12. Curtis has contended, and Potts has denied, that Curtis made rental payments to Potts in July and August of 2019 through the Discover account. Plaintiff subpoenaed evidence from Discover.
I want to highlight that just for a second, because remember there are some people saying that, they didn't subpoena anything. Mm-hmm.
Yes.
Just wanted to highlight that.
Plaintiff subpoenaed evidence from Discover in correspondence responding to plaintiff's counsel's inquiry as to why Discover's subpoena response included no statements prior to October 2019. Discover stated that the earliest statement information they could locate began on October 1st, 2019. The 10/31/2019 statement shows a beginning balance of $0.00, which indicates there was no activity prior, and so no statements were generated prior to October 1st, 2019. Giuseppe, bring me my champagne! So that happened. So Kyle Curtis says that, I made payments to Potts in July and August of 2019. We're like, okay, we subpoenaed Discover, and they said that was complete horse shit because there was no activity in October 2019. So how the fuck did you pay him through Discover in July and in August when there was no activity in fucking October?
That response was honestly not one I was expecting. Like even when they came back with not having those records, my first immediate thought was maybe they're just like in like archives or something. They're like, oh yeah, we gotta go find those separately or something like that. When they emailed back and they're like, oh yeah, we didn't give you any because they didn't exist. It's just like, what?
Like, yeah, okay, so Kyle Curtis, guys, referenced an account in July and August that didn't fucking exist in July and in August.
Yep.
Let me repeat that. Let me repeat that because I want to make sure this is solid. Kyle Curtis, in his infinite fucking wisdom, decided it was a good idea to make the claim that he paid Potts through an account in July and in August that didn't fucking exist in July and in August.
Yeah.
Wow.
And that fact gets even more important later in this.
Yes. Yeah. Shows Kyle to be an untrustworthy piece of shit, and guess what? The judge says that, but in proper speak. 13. Having reviewed the contradicting sworn statements, The court advised counsel that it believed depositions of both Curtis and Potts should be taken. Hey, OPT lawyer, quick question. Did those depositions happen?
Oh yeah, we've got the transcripts of both of them. They're online, they're public.
Ah, boy. Damn. Anyway.
To this day, I am shocked Kyle showed up for his. Just saying.
Yeah. On October 22nd, 2020, transcripts of the deposition of Curtis, ECF number 47.2, and Potts' ECF number 47.1, together with multiple exhibits, were filed. And again, see the ECF number 47. Each continues to challenge the testimony of the other in material respects. Number 15. Yep. At his deposition, Curtis repeatedly claimed that he could access his monthly statements through Discover's online portal and that he would produce statements documenting his rent payments to Mr. Potts. So Kyle said, hey, I can access this shit whenever I want. I can prove to you guys easily that
this is what I meant when I talked
paying rent. I can prove this to you guys.
Yeah, this is what I meant when I talked about that one fact being important later. The fact is, at deposition, he's still maintaining that he can jump into his Discover records, despite the fact that he would clearly know, and everyone else now knows, they didn't exist. So, there comes multiple points here that Kyle could have just fallen on his sword, and, this would pretty much be done. But no, he maintains that this is a thing.
Yes.
When it's clearly not, and it's been shown to not be. That's what I mean when I say this is the strangest case I've ever seen. Because
and you've seen some shit.
I've seen a lot of shit, and I've represented people who are inherently dishonest. I've represented a ton of people who lied to me, their attorney. It happens. This is beyond lying. This is just outright. This feels like he's
legal
just screwing with people. This sounds like he's just screwing with people at this point. Just straight up. It seems like
he's the only one that's going to get slammed for that. That's fucking weird to me.
Yeah, it feels like this is like his playground, and he was just doing whatever he wanted to because I don't know if he thought it was fun or what, but I mean he's gonna find out what happens when you do crap like that. But the fact is, there's no reason for this much effort.
This much effort to hold on to a channel that Kyle has said he doesn't care about.
Yeah.
Keep that in mind, people. Keep that in mind. So again, I'm gonna read that again. At his deposition, Curtis repeatedly claimed that he could access his monthly statements through Discover's online portal and that he would produce statements documenting his rent payments to Mr. Potts. Curtis further testified that he had or would soon have additional materials to support his position, but that he would not identify or produce them at his deposition and would only provide them through his counsel, which, by the way, people, his counsel was in the fucking room.
Right. So, I mean, okay, I will say, in one aspect, it does make sense to provide evidence through your attorney, but when the offer was, okay, we'll step out of the room, show your attorney, and let her decide what to do with it, and he's like, no, that's really when everything gets just so suspicious in his deposition.
If you guys watch the deposition, Steve's lawyer did a brilliant move here, and it's kind of like that meme, outstanding move. He said, I have my computer with me. I would like for you to sign into your Discover statement so that we can see if there's any discrepancies. And Kyle was like, go fuck yourself. It was like, okay, fine. How about this? I will slide the computer over to you and your counsel. I don't have to see anything. Your counsel can state for the record what she is seeing. And Kyle still said no. And then Steve's lawyer said, so let me make sure I got this straight. You are refusing to clear up this bullshit right here, right now. With a computer in front of you, with access to the internet, you are refusing to clear this bullshit up. And Kyle was like, yeah, go fuck yourself.
Yeah, no, to me, it's a clear, I want to prolong this. Just, that's what it's not like.
That's what it was. It was transparent as fuck what he was doing. Anyway, he also committed to provide the original electronic copies of his earlier affidavits to address inconsistencies between them. To assure a complete record before ruling on the motion, the court ordered that Curtis could, on or before 5 p.m. Oh, wait. I like this one. Could, on or before 5 p.m. on November the 5th. Oh, wait. It was remember, the 5th of November. That's right. The meme. There we go. Okay. I fucked it up at first, but I caught myself. There we go. Remember the 5th of November 2020 at 5 p.m. to file the additional items he identified in his deposition. However, he has not filed any such material. Do any of you people want to have a guess why? Could it be that I was right in my tweet when I said that these documents don't fucking exist? Could it be that I was right when I said that these documents don't fucking exist? They don't fucking exist. They're not real. They're in his fucking head. How do you submit something that does not exist?
Yeah. It's
They never existed. They never will exist because they're bullshit. That's why. They don't fucking exist. They don't fucking exist. Period. Looks like I was right. That's right. Okay, number 17. Curtis's attorney... Suck it, bitch! Okay, I'm done now. I'm done. Okay. Curtis's attorney defended Curtis at his deposition and conducted a complete examination of Potts at his deposition. Curtis's counsel then filed a motion for leave to withdraw after the depositions were completed.
Yeah, that is a telltale sign of and none. I want to stress highly, none of this is the fault of Kyle's attorney.
Absolutely
she did
not.
Everything she could to protect her client's rights. And it's telling after the deposition that the attorney, either she herself or her entire firm, just threw their hands up and said, we're done. We need out.
So Steve's lawyer was like, I'm going to ruin Curtis's entire career, and did just that. Then Kyle's lawyer came in and did an examination of Benjamin Potts. And I bet you she was like, yeah, my client is full of shit. And being the professional that she is, she filed a motion for leave. And honestly, I do not fault her. And,
no, not at all.
She is an amazing person, and I wish her nothing but the best in future endeavors. I'm sorry that Curtis became your client. I really am sorry. He's the asshole in this, not Scotty.
Right. Oh yeah.
Okay, perfect. Just making that clear. Nothing but respect for Scotty.
Absolutely, yeah.
The record does not reflect that Curtis provided his counsel any of the documents referenced at his deposition. That seems kind of important to do, but what the fuck do I know? I'm not Kyle Curtis.
Yeah, it sounds like at this point Kyle's been incommunicado.
18. The record is now complete. The motion is ripe for resolution. Ooh.
Honestly, that's normal. That's a normal turn of shit all the time. Ripe for resolution, decision. It's a thing.
So basically, it's like, look, we've been teasing you for a long time, and we're about ready. We're gonna lather up, and we're gonna make sure that you can relieve yourself.
Oh, well, actually, what it means is that the sides have fully briefed the issue. Like the motion, oppositions, replies, everything's been filed. The record's closed. We're done. This is decisional, as it's also called.
I like my overly sexualized view of it a little bit
I mean, I
better.
figured you would. I just wanted to tell the other version of it first before you continued with your fantasy. Go ahead.
uh, if you subscribe to this channel, you know that we love toilet humor. Okay. Standard of review. Rule 55D of the North Carolina Rules of Civil Procedure rules provides that for good cause shown, the court may set aside an entry of default, and if a judgment by default has been entered, the judge may set it aside in accordance with Rule 60B. While the entry of a default judgment is subject to the discretion of the court, North Carolina law disfavors default judgments and advises that any doubt should be resolved in favor of allowing resolution on the merits of the case. Please explain what was just said there.
Basically, the theory in the law in general, and this is pretty much everywhere, is that the courts want to try cases on its merits, or at least have cases decided on their merits, and not by some legal technicality. As much as we always joke about, the guy got off on a technicality or whatnot, the courts don't like to use those as that much because it does prevent, one side from having their day in court, which, again, is something we value in our system. However, there are rules, and if you flaunt those rules, then you get procedured out of court.
Got it. So basically, listen, we want to hear your case. Yeah. So if you're being a little shit about it, we're gonna kind of go against you on that because we got rules, motherfucker. We got rules.
Yeah, and what the judge is also saying in the second sentence there, that any doubt should be resolved in favor of allowing resolution of the merits. Again, it's basically the same thing. It's one of those things. The presumption is you view the evidence in a light most favorable to the. In this case, the person that had default granted to them, or not the default against them, and you say, okay, is there any doubt at all as to this fact? If there is, it goes to the defendant, in this for this motion, and if there's enough here, we'll remove the default. I mean, my court has had plenty of times when a defendant wasn't served properly, and we've removed a default, and 99% of those are not contested because most of the time they're like a credit card company and like, yeah, this is the last address we had for them. And then the defendant will somehow show up and be like, hey, wait, that wasn't my address. I shouldn't get defaulted. And everyone's like, okay, so we'll remove the default. You're here. They file an answer. Credit card company files a summary judgment motion. It ends. Same thing. But, it's still a process.
It's still a process. It's like, hey, listen, before we give you a paddling, we want to hear your side.
Right, yeah. Because you never know. They might have a reason.
Mm-hmm. And just so you know, we just bought these steel paddles, and they're being blowtorched right now. So before we use them on you, we want to hear your side.
Right, yeah.
Okay, so let's see. Default judgment is a drastic remedy which should be reserved for those cases in which one party refuses or fails to attend to his or her legal business.
So that's literally the thing I just said.
Yes. Basically, it's like, look, if you ignore us, you're getting the fucking paddle. And did I mention it's blowtorched? What constitutes good cause for setting aside an entry of default judgment? Quote, depends on the circumstances in a particular case and within the limits of discretion and inadvertence which is not strictly excusable may constitute good cause, particularly when the plaintiff can suffer no harm from the short delay. From the short delay.
Right.
From the short delay. involved in the default, and grave injustice may be done to the defendant. Short delay. 21. An entry of default is more easily set aside than a default judgment under Rule 60B, which generally involves a showing of excusable neglect and a meritorious defense.
Meritorious
defense.
So basically what that's saying is, you remember how I mentioned before the entry of default and then the default judgment? If Kyle had come in with his motion after the entry of default had been issued by the clerk, but before Steve's lawyer filed his motion for default judgment, the standard would have been a lot easier to be like, okay, I mean, we probably wouldn't have even gotten this far. It probably would have just been like, all right, remove the default, let's go.
Yep. And so it says here, just imagine like violins playing in the background.
Mm-hmm.
When the trial courts exercise its discretion in considering a motion to set aside an entry of default, it is entirely proper for the court to give consideration to the fact that default judgments are not favored in the law. At the same time, however, it is also true that rules which require responsive pleadings within a limited time serve important social goals, and a party should not be permitted to flout them with impunity.
So, basically, again, the thing I just kind of said, but it's the idea is that we want litigation to have finality. And if we just allowed somebody to come in years later and say, hey, I shouldn't have had this default against me with no reason whatsoever. Yeah.
Yeah.
Then the longer it takes you to file your motion to set aside, the more scrutiny your motion is going to get. Just saying.
It's like, look, we want to hear your case, but if you're fucking around,
yeah,
we're not going to take that too kindly.
Yeah. Yeah, and some of the defenses to set aside any judgment, including default, you start to lose them after certain time periods. And at some point it gets to the point where the only thing you can argue is, I didn't get served. Mm-hmm. Because if you didn't get served, then the court didn't have jurisdiction to rule on this case in the first place. We had a case where the default was from 2008. It was actually on a motion to revive the judgment. And the defendant came in and was like, I never lived here. I never got this. I only just found out about it because of this other motion. And we had a pretrial hearing, and the plaintiff's attorney was like, yeah, it looks like that's true. In which case, we're just probably going to dismiss because it's so old. Again, it was a credit card thing. It's just it's so old. We don't even care at this point.
We don't even care. Fuck it.
Because then we have to go through the relitigation of the whole thing, and it's from 2008. And they're just like, whatever.
Listen, Your Honor, the next season of Game of Thrones has just been posted. This is really old, and I really want to watch Game of Thrones. So I'm going to go ahead and just say, yeah, I'm not touching this.
Yeah, basically.
Analysis. Oh boy. Ooh. Okay, guys. Hang on 1 second.
Gotta rub up here.
That right there is Dove sensitive skin. All right, let's do this. Okay, analysis. Defendant's motion rests on his contention that he was not living at the Pleasant Garden address at the time the summons and complaint were signed for and delivered to his mother, Suzanne Curtis, as a result of which he was not served as required by Rule 4, defeating any claim that the court had personal jurisdiction over him. Plaintiff contends that valid Rule 4 service was effectuated. So, that's exactly what this whole thing has been about.
Right.
Is Kyle full of shit when he says that he wasn't living with his mother at the time? So, that's where we're at. 23. Where a statute provides for service of summons or notices in the progress of a cause by certain persons or by designated methods, The specified requirements must be complied with, or there is no valid service. Holy fuck. That was a tough read. I will admit I struggled with that one, but whatever.
Yeah, that's a quote from an let me see, what is that, from a 1915 case? I mean, yeah.
Wow. Okay. 1915. Yeah.
That's what it says there. Yeah, it's S. Lohman v. Ballard and Co. Citation that has 1915 in it, and those are quotes right before that. So that quote came from a 1915 case.
So basically, it's like, look, we got examples of this shit already.
Yeah, that is basically back when we were the court system was trying to write in a way that only people who went to law school could figure out.
Sir, this shit that I just referenced, we could have gone to Albert Einstein and asked him about this shit. All right, cool. That's great. 1915. Okay, neat. 24. Rule 4J1A, should be the name of a band, provides that service upon a natural person can be completed by delivering a copy of the summons and of the complaint to the natural person, or by leaving copies thereof at the defendant's dwelling house or usual place of abode with some person of suitable age and discretion then residing therein. 25. Where service of process is had by leaving the summons and complaint with a person other than the named defendant, the suitable person must be a person of suitable age and discretion who lives with defendant in his dwelling house or usual place of abode, and the summons must be left with the substitute person at their usual place of abode. If the summons and complaint were not served upon Curtis as prescribed by Rule 4J1A, the entry of default and partial default judgment entered in this case against him are void and must be set aside. However, when the plaintiff demonstrates legal service was made by an authorized manner, the law presumes service. So basically it's like, listen, we have all this shit saying when we're going to set it to the side. However, the plaintiff did their due diligence in this, and now we have rules regarding that, or we always had rules regarding that, and the rule states that we will presume legal service. We will presume that service was proper.
Yep.
So, 27. The return receipt demonstrating proof of service by certified mail raises a presumption of valid service, which can be rebutted, but is conclusive absent evidence in rebuttal.
Right. So basically, if you just show up and say I didn't get served, the court's going to say, okay,
where's your evidence of that, bro?
Right.
Where's your evidence of that?
It is on the person claiming they weren't served to show at least some evidence rebutting the presumption of service.
Yeah. So the sentence which can be rebutted, but is conclusive absent evidence in rebuttal. So basically, the burden of proof is now on Kyle at this point. The burden of proof is on Kyle, not on
to
Steve.
some extent, yeah. To show at least evidence of like, hey, I didn't get served, and here's evidence to show I didn't get served. Then I believe, again, this may be not North Carolina, at some point then it would come back to the plaintiff and say, okay, he's shown some evidence he wasn't served. What else do you got to show he was served?
Mm-hmm. Although a return of service showing service on its face constitutes prima facie evidence of service, such showing can be rebutted by the affidavits of more than one person showing unequivocally that proper service was not made upon the person of the defendant. The service is deemed established unless, upon motion in the cause, the legal presumption is rebutted by evidence upon which a finding of non-service is properly based.
Yep.
Rebutted by evidence. Keep that in mind. The burden is on defendant. Fucking told you, bitches.
Yep.
The burden is on defendant to rebut this presumption by clear and unequivocal evidence that consists of more than a single contradictory affidavit or the contradictory testimony of one witness. So basically, you're gonna need more than this one dude saying, "No, he wasn't living with me at the time." Why is all of his shit in your garage, and why is his bed in your
right now? Straight up, if none of the evidence Kyle had submitted was falsified, you might have he would have had a much better argument. I'm not going to sit here and say that it would have been granted, but at least we would have a very good back and forth here. But the moment this stuff started becoming false, like known to be falsified, I mean, that bridge collapsed immediately, and then we were just bombing the canyon at this place.
Yep, pretty much. It was like, okay, guys, bring in the nuke.
Yeah, the bridge is gone already, and we're still bombing it. I don't know why, but it just keeps happening.
God, this reminds me of that final scene from Downfall. My Fuhrer, the plaintiff has submitted this evidence and this evidence showing that you're full of shit. And he is about to submit this evidence showing that you're full of shit. It's okay. My affidavit from Benjamin Potts will clear all this up. My Fuhrer, Benjamin Potts got in contact with Stephen McRae. He submitted an affidavit saying that you were full of shit. Shaking hands, shaking hands, shaking hands, shaking hands, shaking hands. Takes off glasses, shaking hands, shaking hands, shaking hands. These people will stay in the room. Brody, Agrippa, Exiled, and Fiona.
God.
Door closes. How dare that fucker go to Steve? How dare that fucker go to Steve? After all I did for him, I sent him flowers when he didn't want any. And this is how he replays me? I'm fucking real! I'm fucking real! My Fuhrer, please calm down. We'll get through this together. How the fuck am I gonna get through this? My ex-boyfriend went to Steve McRae and he fucked me. He royally fucked me with no lube.
Can I ask, did you have that prepared beforehand, or did you just...
No.
Okay, this was just curious.
And then he bows his head and says, "The war is lost."
That's right.
Where was I? Okay, that was okay, cool. Okay. Nothing that service of process should not be lightly set aside, and that overturning the presumption of service is not possible without clear and unequivocal evidence consisting of more than a single contradictory affidavit. Accordingly, plaintiff's service of the summons and complaint to defendant by certified mail to the Pleasant Garden address and delivery to defendant's mother, Suzanne Curtis, at that address constitute prima facie evidence of personal service. Thus, Curtis has the burden of presenting evidence in support of his challenge to personal jurisdiction. And it says that holding that the defendant failed to rebut the presumption of service because the evidence he presented failed to establish clearly and unequivocally that defendant had assumed a new dwelling, house, or usual place of abode by the date of service.
So just let me explain, like in format, what that is, because the judge cites a case at the start of that. It says C, and that means that case has already been cited in this document, and whatnot. When you start with parentheses, that's basically the court or anybody saying that what they're about to write is a holding of the case I just cited to, but it's not worth getting into like paragraphs and paragraphs about it. It's only just one line. So I'm going to just put a parenthetical right here to let you know what the holding of that case was, why it's relevant, and moving on with life.
Thank you very much for that. See, and this is why you are here. This is why we love you.
Aww.
29. Curtis's contention is that the Pleasant Garden address was not his dwelling house or usual place of abode on the date of service, August 30th, 2019. There is no dispute that Suzanne Curtis is of suitable age or discretion residing at the Pleasant Garden address, or that her signature on the return receipt is valid. There is no dispute. 30.
Yeah.
North Carolina law provides no hard and fast definition of what is or is not a defendant's dwelling house or usual place of abode, but rather that it is a question to be determined on the facts of the particular case.
Basically, the court there is saying that there is no hard and fast standards. There are some things in the law where you have elements and specific definitions for things and whatnot. This one doesn't have that. It's a case-by-case factual basis, in other words.
And in this case, we have Kyle jumping around from house to house, but we have one of the addresses that he was going to one of the addresses he was going to is in question, and the guy who actually, owns the fucking house is saying, yeah, that douchebag never lived here.
Right.
So facts of the particular case, those are the facts of this particular case. So, A kind of leads to B, kind of leads to C on this one, follow the evidence where it goes, that kind of thing.
Yeah.
We're going bottom up, not top down, as Kyle would like us have us do. So anyway, the court finds upon the current record that the greater weight of the evidence is that Curtis was residing with his mother at the Pleasant Garden address at the time she signed for the delivery of the summons and complaint, and that Curtis's testimony and evidence is not adequate or competent to support a contrary conclusion. Yes.
So the first three words of that paragraph are the most important. When it says, he says the court finds, that is now the thing the court says happened. Like, that's it. This finding that what you presented is not enough to rebut the presumption, especially because of all of the fraud that we're going to get into. But and that's why I think he added the word competent in there.
Yes.
Because normally it's just not adequate, but the adequate, and I don't know, maybe the adequate or competent is just like a normal thing that they say because of statute or rule or case law, whatever. But I don't tend to see that the or competent in these things in cases that I read for my job. So I feel like that was added simply because of the fact that, the evidence, like because if you look at the evidence just on its face, yeah, okay, this seems to say this, but it's no longer, its authentication is no longer a sure thing.
Yes, exactly. Number 32. Notwithstanding that Suzanne Curtis filed an affidavit that stated when she signed the certified mail slip on August 30th, 2019, Curtis had resided in Charlotte since July 16th, 2019, ECF number 31.2. There is significant evidence to the contrary. Further, there is substantial evidence challenging Curtis's credibility. Burn!
Oh, yeah.
Ooh,
yeah.
Damn. Apply cold water to the burn area.
That's not that's one of those things you need, like
an ice bath.
Dude, that's one of those things you can't put water on. You got to put butter or some kind of fat on because the water's just going to make it worse.
The water's just going to.
Like when you eat something that's stupidly hot because people dared you to.
Mm-hmm.
And you just drink water and just spreads that around. It doesn't actually cure anything. That's the kind.
Ah, I see. So basically pouring water on an oil fire.
Mm-hmm. Yeah, yeah.
In fact, there is strong evidence suggesting that Curtis may have knowingly and intentionally submitted false testimony to the court. There is strong evidence that Kyle knowingly and intentionally submitted false testimony to the court.
I love that line. I love that line for multiple reasons, but the court is clearly flagging, hey, by the way, we're pretty sure you falsified some of this, just FYI.
Man, that one right there. In fact, there is strong evidence suggesting that Curtis may have knowingly and intentionally submitted false testimony to the court.
Mm-hmm.
Oh my. Wow.
Yeah.
The court need not...
That, I was just going to say real quick, that line by itself, just like that line bombs all the haters, period.
Yes.
The court has literally just found, like, oh yeah, he's lying. That's it. That's the end of it.
Mm-hmm.
Boom.
The court need not resolve that issue for purposes of ruling on this motion. The court need only determine whether Curtis has failed to provide sufficient credible evidence to overcome the presumption of valid service of the summons and complaint pursuant to Rule 4. However, number 33, the court will separately consider whether a criminal reference or a further proceeding in the nature of criminal contempt may be appropriate.
So, if I may just real quick, the reason he uses the word criminal contempt is because there's also civil contempt. So, civil contempt is what we were thinking Kyle was going to go in for. Civil contempt is the court compelling you to do something by putting you in jail until you do it. Criminal contempt is the court punishing you for doing something. And there's no way out. In civil contempt, the case law normally says that the contemptor has the keys to the jail cell, basically. He can let himself out and purge himself of the contempt whenever he does the thing he's supposed to.
Yep.
Criminal contempt is, nope, criminal contempt is punishment. You're going to go in this cell and you're going to sit there and think about what you did.
Be in timeout. Oh, and by the way, just so that you're aware, there is #NoBK in prison. Okay, anyway. What I'm trying to say here is that you will not be getting any BK. You will not be getting any BK. You are not going to have it your way. You ain't getting no Whoppers. You ain't getting no onion rings. You ain't getting your large Coke with no ice. There is #NoBK in prison. Yeah, that's right. But, number 34. The court concludes that Curtis has not shown credible evidence adequate to overcome the presumption of valid service. So basically what we have is the trifecta of go fuck yourself. Number 32, number 33, and number 34. The trifecta of fuck you, Kyle.
Yeah, basically.
That is epic. That is epic. 34. The court concludes that Curtis has not shown credible evidence adequate to overcome the presumption of valid service. 35. First, Curtis does not rebut that he had, at least until June 2019, resided with his mother at her home at 1532 Province Church Road, blah, blah, blah. Curtis has neither suggested nor offered evidence of any potential change of address other than establishing residency at the home of Benjamin Potts in Charlotte, North Carolina. 36. Curtis's credibility when offering proof of establishing residency with Potts is in substantial question. Reasons include: A. Potts has denied Curtis's assertion under oath with no apparent personal gain from having done so.
Yeah, that is something the court will look at. It's the benefit or the detriment that somebody has when they when they show up and make a statement under oath that completely contradicts something else. And Ben is actually looking, or Potts is actually looking at a detriment, because if he comes in and makes a statement and he's lying, he is going to be looking at perjury charges perjury charges. But he's got nothing to gain from doing that.
Yep, absolutely fuck all. But my favorite one is B. Curtis admitted to altering an affidavit he filed with the court after it had been notarized to change the date of service through the use of Adobe software.
You know, when I read that, I had forgotten that happened. That was way back at the start of all of this. I had forgotten that happened.
B, I'm telling you,
and
B has a ton of weight to it right
yeah,
there.
and the fact, because what the court here is saying is, look, he's already outright admitted that he altered a document using Adobe, like, yep,
Software.
using Adobe software. Yeah, he's already admitted that he has done this once.
He has the capability of doing it. That
Right.
B right there, what was just said right there in this document,
Mm-hmm.
that is some dense. That is wow. That has some weight to it.
Yeah.
We're talking neutron star here.
Like, I legitimately, if I had remembered that was the thing, like, that would have been the number one point I would have been making this whole time, is to be like, look, Kyle's already admitted he knows how to do this. I had forgotten that even happened over something so stupid like the date. Just have it renotarized.
Yep. That sentence right there hits like Superman with his infinite mass punch. We're talking like, holy fuck. You did what? You admitted to doing what? And after it was notarized? What?
Yeah. Right.
And C, plaintiffs submitted evidence that suggests Curtis may have also have modified Discover statements from their true original form before submitting them to the court, including that the addresses shown on the documents provided by Curtis vary from the address shown on the same documents as produced by Discover in its subpoena response. Ooh, damn. Oh. So basically, Kyle submitted this, Discover submitted that, and Discover is saying that what Kyle submitted is complete horseshit.
Right. Which, again, Discover has literally no horse in this race. They could not care any less about these two people. Like, so straight up.
Mm-hmm. It's something. It's something. Fucking Christ. And D. Curtis testified that he had in his possession other documents consistent with his position, but has failed to provide them to plaintiff or filed them with the court after being given opportunity to do so. So that was the remember, the 5th of November.
Yeah. The court has done so much to, like, throw Kyle the lifeline or the life jacket of to defend or protect yourself. And bravo and props to the court for doing that, because it has given Kyle the ability to defend himself so much, and he hasn't, that it's such a lock at this point.
Yep. And sorry guys, I thought I was already zoomed in, but having a gigantic monitor, whatever. But anyway, sorry about that. Hopefully that's a little bit better for you. Just zoomed in on the text a bit. So yes, he was given opportunity to submit these documents he said he had, which, if I remember correctly, was a signed rental agreement that was done so in pen.
Right.
So I was like, oh, okay. So you have that document? Oh, yeah, I totally do. Okay, and you will be submitting that to us, right? Oh, yeah. Definitely, man, definitely. Oh, okay. All right, sounds good. This just in, Scotty Forbes Lee is kind of done with this shit. Yeah, go figure, right?
Pretty much, yeah. I said it before, but the moment she filed that, I mean, it's like, we all knew it was over at that point. It was just like, the icing on the cake, but it just felt like that solidifies everything when the actual attorney is trying to get off your case, and she didn't even have to say why. I mean, it's clear the reasons.
Yes.
The stuff she put in her motion, just citing to certain professional responsibility codes, done. Like that's all she needed to say.
Yep.
It's the message is clear.
The message is clear. My question, OPT lawyer, to you is this: why is it not clear to other individuals?
um, because they don't want it to be.
Ah, I see. Neat. Um, if I remember correctly, reality is under no obligation to conform to your wants, needs, or desires.
Mm-hmm.
Funny
Yeah,
that.
yeah, exactly. Right.
37. There is further evidence that would allow an inference that Curtis, in fact, knew of and/or received the summons and complaint before default was entered. Service was made on Suzanne Curtis on August 30th, 2019. Potts testified that Curtis did not deny that Curtis was at the Pleasant Garden address the following day, August 31st, 2019.
Yeah.
Text message timeline ECF number 47.14 if you want to see that. The evidence further suggests that the nature and pendency of the litigation was regularly and freely discussed by Curtis and others on forums connected to the YouTube channel that is the subject of the litigation. See, Kyle, you should have taken our advice and shut the fuck up.
Well, and the greatest thing the judge says here is right after that he cites not only to Steve's affidavit, but then to Kyle's deposition to show, hey, just FYI, yeah, as much as the plaintiff is making this allegation, the defendant has outright admitted to this. Just say it.
Yeah, they spoke about it, and in Kyle's deposition, he said, "Oh, so you were sent a copy of this complaint? Yeah, by who?
Yeah,
Nate Brody. Oh, interesting. Okay. Sounds great. Sounds good. You know, in the original papers that I was served, in the original papers I was served, the original papers I was served, the original papers I was served, the original papers that was served.
Yeah.
Thanks, Kyle.
I mean, yeah, by his own mouth.
So Curtis admits that he was given a link to the court's electronic docket in this case. That was again provided by Nate Brody, which would have provided him access to all filings, including the summons, complaint, and affidavits submitting the return receipt confirming the delivery of the materials by certified mail to his mother at the Pleasant Garden address. I also find it hard to believe that Kyle's mom would have been like, hey son, hey listen, you got some shit here? Yeah. 38. There is testimony that while Curtis spent significant periods of time at Potts' house in Charlotte during July, August, and September 2019, he spent just as much, if not more time, at the Pleasant Garden address during that same period. Ain't that something?
Yeah.
Including from August 31st through September 5th. And it references the deposition of Benjamin Potts.
Yep, and those are the important dates because those are the dates that, you know, the lawsuit, the papers would have gotten to, you know, Kyle's mom's house, and enough time for him to show back up home and be like, oh, hey, by the way, you got this in the mail.
So basically, the court's observation in Van Buren v. Glasgow. Indeed, because of his family's continued occupancy of the North Carolina home and because of his regular and frequent return thereto, it would appear that appellant had a closer and more enduring connection with his North Carolina residence than he had with the South Carolina house. Certainly, when all of the circumstances are considered, his relationship and connection with the North Carolina dwelling were such that there was a reasonable probability that substitute service of process at that dwelling would, as it in fact here did, inform him of the proceedings against him in apt time to permit him to assert in timely fashion such defenses as he might have. The court finds that the evidence presented supports the conclusion that the Pleasant Garden address where the summons and complaint were served was Curtis's dwelling house or usual place of abode for purpose of Rule 4 at the time of service on August 30th, 2019.
Yep.
There you go. Right there.
Yeah.
Right fucking
That's it.
there.
That's it. Yeah, that's the court's main finding right there, which is going to be dispositive of this motion.
Yep. Basically, that's it right there. 41. The court finds abundant evidence that Curtis was aware of the lawsuit and the nature of the allegations against him significantly before default was entered and certainly before the partial judgment by default was entered. I just love how the judge just typed that out. And
Oh yeah,
certainly before this time.
yeah.
Basically saying this motherfucker was totally aware.
Oh yeah.
It's clear.
Yeah.
There is abundant evidence for this. And so I would say for number 40 and also number 41 that hashtag Steve was right.
Right.
Imagine that. Now, remember how I said
I mean, to
that-
be fair, this entire motion is saying Steve was right, but order saying Steve was right. But still.
True. I wasn't giving Steve McRae his due respect. So yes, this entire document shows that hashtag Steve was right. In your face, bitches.
It's just
42. The Court of Appeals commented that the drastic remedy of default might be best reserved for cases where a defendant refuses or fails to attend to his or her legal businesses. But this appears to be precisely such a case.
yeah. That's again the judge basically pointing out. Yes, there's a standard of like we should not all. Again, the standard is don't let defaults be the normal. This appears to be the case where this should apply.
Uh-huh. Go fucking figure.
Mm-hmm.
So, there we go. But this appears to be precisely such a case.
Mm-hmm.
God, just epic. It's so beautiful.
Yep.
Okay. All right. I got myself together. Almost lost it there. 43. The court concludes that Curtis has not demonstrated an adequate basis to overcome the presumption of valid service of the summons and complaint upon him by leaving them with his mother, Suzanne Curtis, who signed for their receipt. 44.
Mm-hmm.
The court concludes that both the entry of default and the partial judgment by default were properly entered against Curtis, over whom the court had obtained personal jurisdiction through valid service.
Yep.
Conclusion. For these reasons, defendant Kyle Russell Curtis's amended motion to set aside entry of default and partial default judgment is denied.
Yep.
It is so ordered this, the 20th day of November, 2020.
I'd just like to point out to all those people that were saying that I'm clearly not a real lawyer because I would see the holes in Steve's case here. Just you can all go suck it.
It's okay. You're hashtag not a real lawyer, and Astronomy Live is hashtag not a real coder. You know,
right?
We've all seen this shit before, and the people who are like, "Oh, we already debunked this shit," and then it turns out that they didn't debunk shit.
Right.
And it turns out that the court was like, "Yeah, Kyle is full of more shit than a backed up sewer."
I mean, it's basically the flat earth argument of I've proven it by not proving anything at all.
Mm-hmm. Yeah. So, there you go. At this point, it is clear as crystal that Kyle is fucked.
Yeah.
Kyle is so fucked.
I mean, words and phrases in this order just scream to me the judge is like done. Like with this, like he's given Kyle every opportunity to either stop this from happening or hang himself, and he did the latter.
So at this point, we should also tell the viewers that Kyle has until December 2nd, I believe, to get new counsel.
Yeah, I have that actually pulled up here. Let me get that real quick, because the order for Yeah, and the order allowing Scotty to withdraw, he just doesn't really get into anything worth like reading, but he does say at the end of it, there are other pending motions in this case, including a motion that the court ordered defendant to show cause why he should not be held in contempt. The court will defer its consideration of motions in this matter pending an opportunity for Mr. Curtis to secure other counsel.
Yes.
The court directs that should Mr. Curtis so choose, new counsel shall file the appropriate notice of appearance on or before December 2nd, 2020.
I do not believe for a second that Kyle is going to get a new lawyer.
Mm-hmm.
I don't believe that. I don't believe that for a fucking second.
I don't. Yeah, there are lawyers who would take this. I mean, in so much as I need like Kyle coming in basically is being like, I need somebody to do damage control. And here's everything that happened. I'm thinking he might be able to find somebody to defend him.
Listen, I do not disagree with the fact that there would be lawyers that would happily take this case. I'm saying Kyle is not going to do his due diligence.
Oh no, 100%. Yeah, I was just explaining that there is the distinct possibility that an attorney would be willing to come on to do damage control, knowing that his client is completely screwed. Because I mean, there are plenty of attorneys that most of the criminal defense bar knows their client is screwed from the get-go, but especially because he'd probably have to hire him also for the impending indictment.
Mm-hmm. So this has been fun. This has been great. If there is another update, we will do another one of these. But,
I'm sure there will be when this whole contempt thing comes through.
Oh yeah,
I'm sure.
That's going to be juicy as fuck. That is going to be absolutely juicy. So guys, it turns out that Red's rhetoric was right. Steve McRae was right. OPTLawyer was right. Cheshire was right. Sean Hufford was right. And the people who were fucking wrong are anyone that follows Unirock or Nate Brody. So yeah, suck it, bitches.
Yeah,
suck it. So with that, I'm gonna go ahead and bring this stream to an end. Before we go, OPTLawyer, would you like to say anything?
Vindication.
Yes. You know what? That word is going to be in the title of this video.
Nice.
And with that, guys, thank you so much for watching. And as always, have a good night.